Warm welcome everyone to the third day of the ADR Week India. Today we are very privileged to have a session hosted by CR India and the Indian Arbitration Forum. My name is Yuen Min. I'm a partner at Drew & Napier in Singapore. I'm also part of the Young MCIA Steering Committee. I should inform everyone before we start that this session is being recorded and transcribed. Today, for this first session of day 3, we are very honored to have with us a very distinguished panel of speakers for this session where we'll be discussing the role of GenNext in the field of ADR as arbitrators and mediators. The 4 panelists we have with us, the 4 speakers we have with us this morning are Mr. Lalit Bhasin, who I think needs no introduction. In his 58 years of practice in law, he has won numerous awards, and he's also the immediate past president of the Bar Association of India. We also have with us Mr. Lomesh Nidumuri, who is a partner at Indus Law. He's one of the conveners of the Indian Arbitration Forum, who is hosting this session today. Moderating this session for us this morning is Ms. Medha Sachdev. She is a principal associate with Shardul Amachan Mangadas & Co. She has about 10 years of experience in litigation and ADR, and she will be helping us navigate this session this morning. And last but not least, we have Mr. Shashank Garg, who is a partner at Advani & Co. Mr. Garg is in charge of the Delhi office, and he was also ICC-YAF's regional chapter coordinator for India. Without further ado, I will hand over the session to the panel, and we will also be taking questions along the way. Over to you, Medha.
Thank you so much. Thank you. Thank you for the wonderful introduction for all of us. It's interesting today that we're discussing about GenNext and their role as arbitrators and mediators, especially since not very long ago, a typical arbitrator was famously described as pale, male, and stale. Which was meant to be an indication towards a white man of a certain age. Let's not name the age there. So it's been a very short community which has long suffered from lack of diversity. A lot of effort have been made over the last couple of years to bridge the gap and to make this community more inclusive. But have they been sufficient or not is a debate that is still up for being decided. So, Mr. Bhasin, I put it to you that to start this discussion, is there a need to discuss whether GenNext has a role as an arbitrator or mediators in future? And who are these GenNext young arbitrators?
Yeah, thanks, Medha. I think it's a very relevant and crucial and critical issue that you have raised. It is about what about GenNext? I believe you see that we are all, those who profess to be in arbitration field of law, I think we are all general practitioners of arbitration. What is required now is a specialization within the overall field of arbitration. We need specialist arbitrators, specialists in their respective fields, such as aviation, maritime, construction work, M&As, mining, IT. So at the moment, whether we are retired judges or we are practicing lawyers, we are all general practitioners in arbitration. Yes, we profess to specialize in arbitration, but the need of the hour is to have specialization within the overall field of arbitration. And as you're answering your question, we as general practitioners, particularly there are 2 or 3 age groups. One is the age group where I belong to. This is the senior citizens, you see. And then you have the age group of what COVID says between 45 and 60 or 65, something like that. So that is the phase of the actual practicing lawyers in the field of arbitration. But the third is very crucial, that the young lawyers, the next generation. Now, next generation can achieve this specialization which I spoke about earlier, because there is a scope for the law schools to introduce that sort of a specialization and sensitizing the students, the law school students, you see, who are in their youth, who can adapt, who can accept, who can show their aptitude in different branches of law, and thereafter going for specializations. As Professor Menon, you see, one of the pillars of the modern Indian legal education, he said that in the ninth semester and 10th semester, the young law school students should be opened up for specializations, particularly in the field of litigation practice. And litigation practice, according to him, includes, you see, very importantly, the arbitration and mediation. What he suggested was that the broad themes of practical training in ninth semester and 10th semester will naturally vary according to the career options of the students. And that is where the specialization comes in. Each students and each law school may change every 3 years on the basis of resources available and students. And he suggested that lawyers skilled in trial practice, which includes arbitration and mediation, and avoidance of trial and settlement processes such as mediation, those should be encouraged and brought, you see, in the forefront of legal education, particularly for the senior students who are there in their ninth semester and 10th semester. So I am looking, you see, not at the young practicing lawyers, I am looking at the students, law students, you see, that is the actual next generation which can carry forward this important mission, you see, that I think I must compliment MCIARP and also India Forum of Arbitration for taking this brilliant initiative and having a full discussion for 3 days for the week, which they are celebrating. So my emphasis is that look at the law students. They can bring about the change. Our generation will remain general practitioners in the field of arbitration. We cannot look for, you see, therefore the message should go to the law schools, the young students, and they can bring it forward. Thank you.
Thank you, Mr. Bhasin. That was very, very useful. And that's a very nice message that you said, that it's actually the students who need to be trained and groomed to become the Gen Next arbitrators and mediators. However, very interestingly, a very recent survey that the Queen Mary University conducted, asked a bunch of, well, not a bunch, thousands of lawyers across the globe, who are these Gen Next, who are the young arbitrators, and whether there is inclusiveness for them in the arbitration community. And the results, though not dismal, were not extremely impressive either. And interestingly, in that report, there was no consensus in the respondents as to who is a young arbitrator. And what caught my attention to that report, and why I'm presenting this to the panelists here, is that many thought a young arbitrator is one who is 50 years or younger than 50. So, it's interesting because I think people consider that the age of an arbitrator, starts, the median age is 60 years and above. So 50 years is a young arbitrator as per many. What are your thoughts on it, sir? And then we can leave the question open to the panelists as well.
You're asking for my thoughts?
Everybody's thought. Yes, sir. Starting with you, sir.
Okay. No, my thoughts are, you see, that no, 50 is not the correct age. I again emphasize that this next gen for me would be the law students and not the young lawyers who are practicing. And young according to you, would be up to the age of 50. You see, we have retired judges who retire at the age of, in High Court in 62 and Supreme Court 65. They are always already accustomed to certain way of law practice. Whether as judges, they hear the lawyers and then earlier they were practicing. Therefore, they cannot bring about any major change. I may be an FCIARB, but still I consider myself, you see, as a general practitioner in the field of arbitration. If some case comes to me, say in maritime law or aviation law, I will be able to do it. But am I doing justice, you see, to the system that there should be proper specialized panel of arbitrators, not just confined to judges and lawyers. The other experts should also be roped in. And that is where the next gen, when you talk of, do not consider only the lawyers, you see, the young law students also. I think we have to broad bases to bring in more specializations to make arbitration and particularly mediation more effective. You need trained arbitrators, trained mediators, and for training, you need specializations.
That's very well said, Mr. Bhasin. And coming from you, it's actually very, very valuable that people of a certain generation, people who have been used to and accustomed to a certain process, will bring that process into arbitration as well. And perhaps it's time to widen the scope. May I please ask Mr. Nadumuri for his opinion, please?
Yeah, thanks so much, Medha. So, I mean, I did hear your thoughts on this age bracket of 50. I'm in my 40s, so I'd like to believe that people in their 40s also are next generation in that sense. But I do subscribe to the views that Mr. Bhasin made. I think he made a couple of excellent points. The first thing is when you're looking at next generation, I don't think that should be pigeonholed into any kind of an age bracket, because it would really depend on the nature of specialization that you're bringing into in that particular area of arbitration. For instance, if it is a very technical or a niche area of arbitration that you're talking about, for instance, technology, you could have somebody in their 30s who's started their own company and who has excellent knowledge insofar as software code is concerned. So it's not necessary that somebody in their 40s or 50s only should be considered as an expert in that field. Whereas, of course, when it comes to a lawyer, the parameters may be slightly different, only because as lawyers, we're also groomed not just to know the technical aspects of it, but also insofar as the conduct of arbitration. How do you really control and conduct an arbitration? That's where your experience and your forte really comes into play. And that is why maybe the age bracket shifts a little more when it comes to lawyers. But as I mentioned earlier, the class barriers have been broken. Gone are the days when you're looking at even 40s and 50s. I know excellent distinguished colleagues of mine in their 30s who are doing exceedingly well as arbitrators. And a lot of them have even chosen to be only an arbitrator and not even an arbitration counsel. And that is a level of specialization that you're looking at. People who say that I will not act as an arbitration counsel at all, I will only act as an arbitrator. But of course, I can think of a handful of them who have done it, Anish Wadia and a few other people who have done it. But I think that is a level of sophistication that's going to come into the market. Mr. Bhasin spoke about specialization across the fields. I would think that even between the arbitration practice itself, there would be specialization between somebody who would say, I'll act only as an arbitrator, and somebody who may say that I'll act both as an arbitrator and as a counsel, or somebody who may say they'll act only as an arbitration counsel.
That's very interesting. Mr. Garg, if we can have your thoughts as well.
On the lighter side, taking cue from what Mr. Bhasin said, I feel everybody who has not been vaccinated is in the Gen Next, that is below 45. But a very pertinent point, both Mr. Bhasin and Lomesh pointed out, why should we have any sort of, demarcation, even if it is 30, 35, 40, 45? If we look at what is the eligibility to be a judge in our country, a 22-year-old law graduate is eligible to appear in a judicial examination and become a judge. In many jurisdictions where, such as Haryana, where original jurisdiction has absolutely no pecuniary limit, these young judges would be deciding cases worth hundreds of crores. So why should there be a mental block when it comes to arbitrators with respect to their age? We often hear this very famous term, age is just a number. And that is usually used for people who are old, who want to hide their age, and never used to empower somebody who's younger to say age is just a number. Doesn't matter whether you're 25, 30. If you have the relevant expertise and if parties have confidence in you, why should your age matter when we're appointing you as an arbitrator or a mediator? But there are a lot of cultural and mental blocks, which I think today, while we'll discuss this further, we'll come across and try and find some solutions.
It's interesting you mentioned the mental blocks, and that's often spoken about when it comes to generational diversity, that there are these mental blocks that people hold against people of a certain age, and they would maybe lack experience, maybe there'll be an impact on the quality of decision making, etc., etc. So both you and Mr. Nadumari as young arbitrators, did you face any difficulties, any such biases or prejudice against you because of your age, if when you acted as an arbitrator or even as an arbitration counsel? Did parties come around and say, well, you're too young for our case?
Lumesh may go first.
Well, sure, thanks. So, I mean, the biases were there. Maybe subconsciously it is rooted in people. When they see somebody a lot younger, appearing either as an arbitration counsel or acting as an arbitrator, there is a kind of subconscious kind of a bias which is there rooted in people. But I think the trend has changed largely now. People do recognize that there is quality of advocacy that can come from somebody who is much younger. People have opened up their horizons. People have opened up their avenues to say that there is a lot of value that somebody much younger can bring to the table. And let me make a distinction here. Insofar as arbitration counsel is concerned, arbitration is actually an excellent forum for youngsters to stand up against senior advocates or much more senior members of the bar. The reason is, it is not a jurisdiction under Article 226 of the Constitution of India, where there is some kind of a discretion on whether to grant a stay or not to grant a stay. Arbitration is all about hard facts. It's about evidence. It's your ability to read the evidence. It's your ability to lead the right evidence, the right witnesses, and it's your ability to cross-examine the witness. These are skills that come to the forte. And usually what happens is, with due respect, I mean, there are senior advocates who spend a lot of time reading the brief and who are excellent, but you also come across situations where they do not have enough time to prepare. That is where somebody who is much younger, somebody in the 30s or 40s, can really take on a senior advocate and do really well in the arbitration sphere. Whereas in the court, it has its own old baggages of, its own, the British colonial culture of, seniors and, the whole biases, which I don't want to talk about. And those things are always there, which are not there in an arbitration. So I think it really works to your advantage. Insofar as bias against a young arbitrator, I think, yes, the bias against a young arbitrator is a lot more, I would say, than an arbitration counsel, because arbitrator is somebody who's going to decide the case. And let's assume a situation where you have two senior advocates appearing for either sides, and you're a young arbitrator in your 30s or 40s, and you have somebody in the 50s or 60s. I think one is, the initial bias is going to be that this guy is a youngster. This person, the guy or a girl is a youngster. Will he or she be able to render the right award in this particular matter? Will they be able to conduct the arbitration proceedings properly? That initial bias will always be there. But I think the moment they realize that you're firm as an arbitrator, 2, you're fair as an arbitrator, 3, you have the right principles of integrity and values, and 4, that you have sufficient knowledge in order to understand the case and to pass a reasoned award, and 5, that you have requisite patience to deal with the parties, I think immediately you garner the respect of the parties who are appearing before you and even the senior advocates that appear before you.
That's very interesting. And if I can just put another question back at you for the description that you just gave. You spoke about how if the party is able to, get some sort of a respect for the young arbitrator, they would be willing to go ahead. But in the manner in which the appointments are made of the arbitrators, not very often do you get a chance to interact with the parties ahead of the appointment. Not certainly in a manner that you can show these skills and invite confidence and respect from the parties. And often that is where the ball drops for young arbitrators, and that is where, looking at the list of panelists, parties often just, the names that they haven't heard, they're very wary of selecting them, they're very wary of going ahead with them. Even if an institution is to say impose, if not impose, at least suggest or push a young arbitrator on the parties, they would often be very wary of it. And there have been instances where technical, criteria were picked out by parties to have them disqualified or remove the arbitrator, etc. There have been instances in ICC and other such institutions as well. So in that light, how does a young arbitrator deal with this limitation?
I mean, the limitations are always going to be there, Medha. So, it's a mindset of the people that needs to change. It will take some time for it to change. And institutions also, I think, have taken a great step forward in making sure that the younger arbitrators are being appointed as arbitrators. That trend is also changing. But obviously, we are nowhere close to what the international standards are. And the average age of arbitrators in the country is definitely on the higher side, and that needs to come down. And the more the younger arbitrators really take on the mantle, the more they're able to prove their mettle. The more the confidence that parties also have that younger arbitrators will be in a position to handle a complicated arbitration, and that's always a ripple effect that happens that happens over a period of time. And the younger arbitrators just need to have a lot of patience and just trust their own abilities and just proceed with the arbitration.
Interesting. If I can have Mr. Garg's thought, and then we can go to Mr. Bhasin for his valuable thoughts.
Medha, as far as I am concerned, my experience has been very heartening and very positive in this regard. So speaking purely from my own experience with appointments done in Section 11, Delhi High Court has been very, very progressive. So is Bombay High Court and some other jurisdiction that I hear, where judges in Section 11 have been appointing the younger lawyers in disputes. Now, when we talk about parties choosing a young arbitrator, as Lomesh was pointing out, it's a free market. So one will really have to break that mental block for the parties. There is nothing that can be done other than parties really feeling the need, really finding out that a person with, in his early 30s, early 40s is capable to handle a complex, dispute. We can't really change that. But as far as appointments through court and institutions are concerned, I think we have seen a trend wherein even international institutions like MCIA, DIAC, etc., have been appointing young lawyers as arbitrators. High courts have been appointing young lawyers as arbitrators. So I think the future is really bright. The opportunities are coming in. And young arbitrators also have a huge responsibility. They must, upgrade their skills from time to time, so that these are not just philosophical questions. When responsibility is actually put on them, they are able to perform up to the mark.
Mr. Bhasin, if we can have your thoughts as well.
Yeah, I think there is a slight divergence of view so far as I am concerned, because we are speaking about young lawyers straight away being arbitrators. I think that is not the correct approach. First, lawyers have to establish themselves as lawyers in the field of arbitration, appearing for parties and all that. You can't think of a young lawyer just becoming an arbitrator straight away. Once he makes a mark in the profession before the courts and before the arbitral tribunals as a young lawyer appearing regularly, then there is no question of bias. Then he'll be recognized for his own merit. Age does not come in there. We have so many people here. Lomesh spoke about, Wadia, and then there is Nakul Devan and all young people, but they don't claim to be good arbitrators straight away, because they have been good, successful young lawyers, and their talent has been recognized by the courts. As Shashank rightly said, the Section 11 judges are appointing, but they don't appoint someone because he's a young lawyer. They appoint someone as arbitrator whom they know. You see that he can be a good arbitrator because he's frequently appeared before them in arbitration matter. Therefore, what I feel is that there is a bias. And Medha, you would be interesting in, there is a bias against women arbitrators and women mediators. In my experience now, which is about 60 years, I have not seen many women lawyers or otherwise as arbitrators. There is a big gap, particularly in India. I don't see anyone coming up, in the field. And that possibly is not because of lack of effort on the part of the ladies. They do deserve that recognition. But there the question of some sort of a bias comes in, which is most unfortunate, because our lady lawyers are second to none. And they can be actually very good mediators because they inspire confidence by very nature of things. But they have not been given their due. under the Indian arbitration scenario or mediation scenario. So there is definitely a bias for young ladies not coming up, as they may be good lawyers, but somehow you see when the question of choosing the arbitrators or mediators is concerned, they are not considered. There is some inherent bias there.
Thank you, Mr. Bhasin. That's actually true. And yes, Ms. Nidamari, please.
Yeah, I think I 100% agree with Mr. Bhasin. I don't think the approach should be that, yes, Generation Next, we are all excited about the Generation Next. Let's all make them arbitrators. I think that's not something that, I'm sure Shashank's views are also the same. I don't think that's something that we should all rush into. Obviously, being an arbitrator is a very, very responsible job. You're substituting the role of a judge. You need to have the requisite experience and the skills to deal with an arbitration. And let me also point out that just because you are a great arbitration counsel need not necessarily mean that you'll make an excellent arbitrator or even a mediator. There are requisite skills that are required for you to be an arbitrator. You may draft your petition really well, you may draft your claim statement really well, but when it comes to actually drafting an award, you cannot afford to make any kind of a mistake. I mean, lawyers do make mistakes here and there when it comes to drafting pleadings, but you cannot afford to do that when you're determining the rights of a party. And that is where I think a little bit of experience definitely helps, and some kind of technical skill set that institutions like the various institutions that are there, and including IIF, that's one of the philosophy on which the IIF is also there, is to ensure that we create the next generation of arbitration lawyers who also aspire to become arbitrators. And we want to create that whole ecospace in the country where people also take up the profession of arbitrators itself a lot more seriously and have the requisite skills to do it. I think that's very important. It's important that we don't rush into it just for the sake of it. And it's important that we create the requisite technical sort of expertise and the right kind of training also to groom the next generation to take on the mantle of arbitrators.
That's very interesting point.
Can I just close the loop by clarifying what I said? And I think both Mr. Bhasin and Lomesh have made the same points. But when I say young lawyers are to be appointed or are being considered for appointment, as Mr. Bhasin rightly said, it's not akin to appointing somebody like a local commissioner, who obviously the judges appoint LCs looking at a young lawyer or an LR, giving them some sort of financial help. Very rightly said, I think the responsibility of an arbitrator is huge, especially given the fact that the scope in 34 is so narrow. So you're almost giving somebody the role of a judge who in his quasi-judicial authority would be writing an award which is very unlikely to be interfered with unless you go horribly wrong. So therefore you need somebody who obviously has the basic skill set. So I think we all agree on that there cannot be a straight away becoming an arbitrator sort of a journey or ambition. The idea should be to transition from a practitioner who's doing specialized arbitration to an arbitrator. And as Lomesh pointed out, that may also be not everybody's cup of tea, or everybody may not want to do that. People may just want to remain successful practitioners. So we have to consider all these factors.
That's right. But that just that begs the question that what are these skill sets of an arbitrator that one must possess? How do you determine that you have now achieved a certain experience that would make you, viable as an arbitrator? Is it attending certain courses? Like I know CIRB offers a course to become a fellow with them, and that they teach arbitration writing as one of the last examinations, etc. Is that a skill set that one must possess? Is it something else? How do we put, for all many young arbitrators or wanting to be the next arbitrators in the audience, what would you say are those skill sets that one needs to acquire in their journey as an arbitration counsel?
We should start with Mr. Bhasin. We're all learning from him.
Absolutely.
And I start again with the law school. You see, all this as has been explained very eloquently by our other eminent panelists here. You can't suddenly become an expert. Getting expertise is an evolution, you see, evolutionary process. And when should that process start? It should start with the law school. because I firmly believe that the students of law who are the future lawyers have to be prepared for a special role in the administration of justice. They have to be prepared and molded to be good advocates, good judges, good legislators, good arbitrators, and good mediators, so that they are able to, and this is important, understand not only the legal rules, but also their socio-economic and political backgrounds in which they are framed. And they should also be able to understand judicial, legislative, and administrative institutions that and their true role to the society. They should be able to understand a lawyer's skill, not only of investigating, that is what Lumesh rightly highlighted, and investigating, interviewing, and negotiating, but also helping, counseling, and mediating. And also to understand not only the theory and mechanism of dispute settlement resolution, but also take part, this is important, take part in providing access to justice through non-judicial dispute resolution mechanism like arbitration and mediation. That is how you will build up, you see, this institution of arbitration and mediation. If you start, you see, from the law school, that responsibility has to be given to the law school so that they can evaluate the aptitudes, you see, or the inclinations of the law students for particular specialization and inculcate in them, you see, this need to have specialization so that administration of justice can be done in a very effective way, because litigation has failed totally. Therefore, people are now looking at arbitration and mediation. Arbitration also in India has yet to take off for so many reasons, including that it is monopolized by retired judges and lawyers and all those things. And we have too many laws and all that. But more importantly, mediation seems to be the answer. And you do need trained mediators who inspire confidence. And that is where the role of our lady lawyers and jurists and all that comes in, because they can be really very successful mediators, as we have seen in the Delhi High Court Mediation Center. It is being, I can't say manned by, it is womaned by, you see, many eminent young ladies who are delivering, you see, this, helping in this noble cause. So that is my
Mediation
take.
and arbitration both. Right, sir. If Mr. Garg and Ms. Nidumari can share their thoughts.
Should I go, Shashank, or do you
Yes,
want to go
yes,
ahead?
Lumesh.
Yeah,
I'll
great.
follow.
Yeah, so there are two aspects to this, Medha. One is you're talking about future of generation next in the field of ADR as arbitrators and as mediators. I think when it comes to mediation, since your question is what are the skills that are required, I think the first rule of mediation is to unlearn what you've learned as a lawyer. And for that, you need some kind of a technical training that is required for lawyers to unlearn what they know. Otherwise, you cannot act as a mediator unless and until you forget about what it is to act as a lawyer in that particular matter. I think that really comes with training. You can't just today decide that I'm going to be a mediator and then sit and mediate disputes between the parties. Some may be innately good at doing it and may be doing it well, but I do believe that there needs to be some kind of a certification that is a minimum requirement for somebody to act as a mediator. And for younger members of the bar who are interested in becoming mediators, they should really look at getting those kind of technical trainings from various institutions there. That is insofar as mediation is concerned. Second point is insofar as arbitrator is concerned, I think we all agree that there is a certain level of experience that is needed for somebody who's an arbitration counsel to act as a as an arbitrator. There are excellent courses that are offered by CIR and few other institutions. I think that should definitely be a sort of a starting point for somebody who's looking to be an arbitrator to take those courses, because these are one of those very few courses where the lawyers actually go through the grind of writing an award, because writing an award is a different skill set altogether. As I pointed out earlier, you can't just give those gibberish and keep it a very repetitive pleading like what we do as lawyers. You have to be extremely clear about your structure of award. What is it that you're going to put right on top? What is the analysis? What are the issues? How do you crystallize it? And how do you conduct an arbitration? That's also very important. And particularly in today's times, where a lot of things have gone virtual, you should also be having the requisite technical skills also to ensure that you're able to keep with the times. And on another point, what I have is, and I think this is more at the policy level, that is something that the government of India may consider at some point of time, is to have some kind of a qualification, kind of a course centrally, or maybe it is at the state level, where people have to pass an exam, just like you have solicitor's exam in the UK, you have the IRP exam where you have to pass that in order to become an IRP. Maybe have something like that for India as well, to ensure that there is a minimum standard that is maintained. Otherwise, there is no way to gauge standards today, because it is all based on, let's try this particular arbitrator, let's find out what the market information is. If he or she is good, we'll get more mandates, but those 2-3 mandates may actually get messed up in the meantime. And as Shashank said, there is very limited scope for appeal also, and the parties will be left in the lurch. So I think it's important to keep that base level of credibility and technical competence in the market, and that has to evolve over a period of time.
Thank you. That was very, very useful. Mr. Garg, if we can have
Mr. Bhasin and Mr. Lomesh has already covered the aspect of skill set that is needed for Gen Next arbitrators and mediators. Let me just point out some things that you could do to acquire that skill set, and which would be of some relevance to the younger audience. I think many initiatives across the globe have been taken to upgrade the skill and to absorb these young practitioners into the world of arbitration. Young MCI is one such example. We have all the leading institutions across the globe, including LCI, which has a young arbitrators group. ICC has YAF, ICSID has Young ICSID. There are mentoring schemes run by ICA. Indian Arbitration Forum recently started an essay competition for younger lawyers and law students and offered mentoring from some of the IF members and internships. So these are some of the areas that a young student and even a young lawyer should look at in order to get some sort of a basic orientation and exposure to the world of arbitration, because some of these events, some of these conferences like the one we are holding today are extremely useful, and one will only get to know if you're involved in those circles. Moving on, I'm sure masters is a way out. CR courses are a way out to learn those technical skills. Very important skill of award writing, which is essential part of the CIR's fellow course. Unfortunately, in India, we do not have any such course other than obviously the course offered by CIR, that anyone who wants to be an arbitrator or who's planning to start his practice as an arbitrator can learn the art of award writing. So as Lomesh was saying, I think we all need to learn, then unlearn, and then relearn. And this was in fact a statement made by Chief Justice of India 3 years ago in a conference where all the arbitrators or arbitration councils were present, saying that just because you're a former judge does not make you a good arbitrator. There are a lot of skill sets, there are a lot of new things that you need to learn before you perform the function of an arbitrator. And if that level of consciousness is there for the experienced lot, I'm sure the younger lot has to follow the same principles as well.
Right. Now, if I can just add to that, because I know a lot of questions have come on what can be done by younger arbitrators. There is a very interesting opportunity that's coming up across the world called tribunal secretaries. And I know CIR is doing a lot in that field. And that I feel is akin to being a law clerk with a judge. So it gives you immense exposure, immense learning experience to be sitting with an arbitrator and learning from there, assisting them in administrative or maybe sometimes even putting papers together, understanding what thought processes go while writing an award. So that can be a very useful avenue for young practitioners looking to become arbitrators. With that, moving on, because I know with time is running out, so I'll quickly ask last couple of questions, and we can take on the audience questions. To improve the scenario, and I know we have spoken much about there has been a lot of headway made, and not limiting young arbitrators to be that of students, but many people like yourselves, to improve the scenario for you to become arbitrators, to become the usually appointed arbitrators as opposed to judges. Because I know in India, and I'm sure you will agree, the first go-to person for an arbitrator is a judge, is a retired judge. Those are the names that everybody first wants to explore. And only then do they move on to councils, that to senior councils, and then maybe the list goes to younger practitioners. Who or where do you think the change should begin with to change the mindset, to change the whole process? Because like Ms. Nijumuri in the very beginning pointed out, for specialized courses, specialized disputes where experts are required, very often you will find younger practitioners to be more useful as arbitrators, or at least one of the arbitrators on the tribunal, if not the only sole arbitrator. So where can we start? Is arbitration institution the right place to start? Is a regulation or a rule required for this? Do we have to change the mindset with parties, yourselves as practitioners? Would you change the thought process that parties come with when they come to you for suggestions? Where do we start?
Yeah. You see, you have hit the nail on the head when you mentioned about institutions and all that. In India, we do not have good institutions which inspire confidence, except, you see, that as the MCIA. We always give an example of this MCIA, but then that is just one institution. Why arbitration has failed to take off in India is also primarily due to the fact that we do not have good institutions of arbitration. Now, by institutions of arbitration, I do not mean that they should be just centers of having arbitration proceedings or even suggesting or appointing arbitrators. I think it should be an integral part of every institution to provide training programs, you see, to the young and emerging lawyers, particularly what you call the Gen Next. I think there should be programs, training programs, courses to be conducted by these institutions, other than, you see, apart from what they are doing as good institutions. In India, of course, we don't have. But take example of the LCIA or the ICC or SIAC and uh, American AAA and all that. You see, they are all doing great job, not just in the field of arbitration, but strengthening the entire system by having these training programs and courses. Therefore, in India, we lack also what is called an arbitration bar. As I said, we are all general practitioners. Today, I'll appear in a arbitration matter as a counsel, or I may be an arbitrator. Tomorrow, I'll be appearing before the High Court, you see, trying to argue some matrimonial matter and all those things. So we do not have a designated arbitration bar as we have in the other jurisdictions. That is what is important for us to develop. And secondly, as again rightly pointed out, contemporaneous developments what are taking place all over the globe. Because arbitration is not just now domestic arbitration. Arbitration is now international arbitration, multi-dimensional arbitration, multi-party arbitration. So what are the contemporaneous developments? And that can only be provided, you see, by a good institution who have the wherewithal so that they can share it, you see, with the young and emerging lawyers or arbitrators or mediators. That's my take on that.
Thank you, Mr. Bhasin. You're absolutely correct. Ms. Nijumuri, if we can have your thoughts.
Yeah, I think it starts really with the mindset, which we spoke about earlier. Secondly, I think what is also important is to increase your pool and base of arbitrators. And where are your next arbitrators going to come from? I mean, all this talk is great. We're going to say generation next. We are going to be very good, etc., etc. But ultimately, you need to create that pool of arbitrators who can be appointed for future disputes. If you don't create that, then everything is just meaningless. The third point which I wanted to make is, if you're looking at some institutions like ICC, the average age as of 2018, I have the statistics here, was the appointment age was 56, and with only 35% less than the age of 50. And ICC, for instance, has taken a lot of initiative in ensuring that the age is drastically reduced. I know SIIC, for instance, is also making those steps to ensure that the age is reduced. While all measures are happening, again, I come back to the same point that you need to really increase your pool of arbitrators. Because while you say we're going to reduce the age and we're going to give more opportunities to the younger arbitrators, but where are your arbitrators? If you don't have your pool of arbitrators ready to take on the challenges which are required of you to be a really good arbitrator, then you've really lost the plot. So the start should be increase your pool of arbitrators, and at the same time do everything else that is required, right from institutional changes. And Shashank also spoke about some of the younger forums, what they're doing, right from YSIC to YNCIA and all the other forums, which is to really give the younger bar and the students the requisite skill and the tools to become arbitrators in the future.
You're absolutely right, sir. And in fact, it merges well with what Mr. Bhasin just said. To identify this pool of arbitrators, we need to have, maybe a list, maybe a group, either it be an arbitration bar, maybe it may be an institution which has a panel of arbitrators. Because often when parties come to councils for suggestions of names, we refer to the panelists on the panel of various institutions such as ICC or LCIA. That is usually the reference point. So that is what is lacking in India for young arbitrators or even otherwise for arbitrators. And a lot is dependent on word of mouth. And word of mouth then limits and enables repeat appointments. And repeat appointments are certainly a barrier for opportunities for the younger arbitrators. What are your...
One more point, Medha. Sorry, just one more point. Sorry to cut you short. And that is something that we at the India Arbitration Forum are also aspiring to do. The forum is essentially a bunch of law firm partners and younger practitioners who have come together, who've forgotten their differences. I mean, you could be opposing each other in matters. You may have argued against each other, tooth and nail in matters, but we have just come together with the sole objective of actually improving the arbitration ecospace in the country. And to also create the next pool of arbitrators. It is work in progress. Obviously, there's a lot more that we need to do. And that is where we can really benefit from working with Mr. Bhasin and the other reputed practitioners in the country to make sure that we really drive home the message to the younger members also that the future is bright insofar as arbitration is concerned, and also the fact that there are opportunities for you to act as an arbitrator and a mediator in the country. Sorry, Shashank.
Very important point. A very important point. So it's very important for the youngsters to see that there are opportunities to be able to work towards them. Mr. Garg, if we can have your thoughts as well.
So, in fact, IF and CR both are institutional neutral entities, and both are in the space of creating those best practices, inculcating those best practices, not just within the Gen Next, but for anybody who's now interested in arbitration. So initiatives by IF and CR are the things that everybody should watch out for. Now, coming back to your question, Medha, quickly on institutional arbitration as well as ad hoc arbitration, there is a slight difference. Institutional arbitration, as put by Lomesh, if there is a good pool of arbitrators, institutes have already started the trend of appointing younger arbitrators. But what happens when we are looking at an ad hoc arbitration? And as you said, when parties come for a suggestion, the council would usually not name somebody really young. So this brings me to the same point I made. It's a free market, Medha, and you can't choose a judge. You will have to go to the relevant court as per the jurisdiction. But you do have a choice when you're choosing your arbitrator, and every party wants to exercise that judiciously. Therefore, what we really need to do is break that mental block, increase the level of confidence, within the parties to appoint these Gen Next younger arbitrators. Because if you keep forcing them, there is a very easy way out. Parties could simply put a clause which will say that the arbitrator must be a former judge of a high court or Supreme Court. What do you do then? So it has to be a comprehensive effort. It has to be inclusive sort of a growth. in the minds of the parties as well as all the stakeholders.
Absolutely so. And like you said, courts have already started encouraging younger practitioners, so that ought to give some sort of confidence in the minds of parties that there is scope for younger arbitrators as well. Since we only have 10 minutes left, I think it's now time to go to audience questions. I do have a bunch of more questions.
I think Mr. Bhasin is saying something. Sir, you're on mute.
You wanted to say something. Yeah, you're on mute, sir.
Yeah, no, it's I'm tempted to say something about the ad hoc arbitration, what Shashank just mentioned. You see, the answer for arbitration to succeed in India will be that there have to be good institutions. Ad hoc arbitration will not be the answer, because I have seen, and that is the mindset, and we are not talking about the mindset of the arbitrators or the mindset of the parties, the disputing parties. I have seen, you see, and I've experienced that, people saying, the party saying, look here, that we appointed someone as our nominee, he is decided against us. Now, you see, that sort of an approach, when you have an arbitral tribunal, you see, where one party nominates, other party nominates, then they do so, the mindset has to change. And that mindset will not change easily. Therefore, the best answer is to institutionalize arbitration. That is the answer. Ad hoc arbitration will not make arbitration take off in India. It will be a total failure, you see.
Absolutely, absolutely, sir. Often we hear parties saying, let's have a CJI so that when the award goes to the court, it will be a different eye that will be looking at the award, and a different, very maybe more favored. Okay, so we'll take up the questions. Let's start with the first one that we have here. It says, as a norm, preferred arbitrators are usually baby boomers, retired judges, or senior advocates. Then in the current scenario, Gen Next or Gen Y have avenues open for arbitration. But what about Gen X advocates who want to diversify their careers and plan to become arbitrators? How should they go about it? I think we did cover a lot on what needs to be done. I feel this has been answered. So we'll move on to the next question, please. If any of the panelists have anything to say, please feel free to jump in.
I would just say they should look at CR.
I have only one thing to say.
Yes.
I'm just leaving the meeting.
Thank you so much, sir, for your valuable time and all your thoughts, sir. Thank you.
Thank you, Mr. Bhasin.
Thank you. Thank you.
Thank you.
I was just saying they should look at the CR and IF website, and most of their answers would be found there.
Right.
You know, there are courses, there are things that they could do to transform their relevant practice to a dispute resolution practice.
Agreed. Many companies are trying to open online mediation platforms for resolution of disputes, and upon failure to start arbitration. Do you feel that online arbitration platform will empower younger arbitrators to stick with the arbitration deadline of timely submission of application and have the arbitrator to go to give a reasoned award within the time frame devised by the Arbitration Act? Well, if any of you want to take this.
Yeah, I think the online arbitration system, a lot of them have indeed started. And I think it's a good platform for youngsters also, for some of the younger arbitrators to take on some of these disputes, because some of these disputes are not super complicated also. So it may be something that is within their comfort zone as well, because for a younger arbitrator to suddenly handle 1,000 crore, construction dispute may not be up their alley, but these are disputes which are not so complicated. So it may actually be in their interest to sign up for some of these institutions where they can act as an arbitrator and also pass the award within a reasonable period of time. And most of these are document-based arbitrations, so you don't really need the requirement of conducting trial, etc. Though, of course, there are exceptions and you do conduct it. So I think it does provide an excellent platform.
Absolutely. In fact, ICC also has recently suggested this to its national committee, that when you're appointing arbitrators, if it's a less complicated case, go ahead with younger arbitrators. So that encouragement is certainly happening world over. What are the prospects of international arbitration seated in India by 2030? Wow, that's a very interesting question. Mr. Garg, we can have your thoughts on it.
You see, I think for the last 10 years, we've been hearing this in conferences. Can India become a hub of international arbitration? What are the role of institutions? What are the role of judicial pronouncement? What are the role of other stakeholders? We've debated this a lot. But the takeaway from all these debates and what we've been seeing is that judicial pronouncement in the last decade or so have been very, very progressive. Supreme Court and many high courts have been, giving out very arbitration-friendly judgments. The interference that used to be the norm is completely now done away with. There is a huge amount of reluctance in interfering with an award unless it's perverse on the face of it. The scope, as legislative amendments have reduced, the scope in 34 has been, redefined, reshaped, and has been made really, really narrow. And as far as international arbitrations are concerned, the Supreme Court, time and again, in execution petitions, have shown, has frowned upon any delays, imposed huge cost on parties delaying execution, etc. So I don't see a reason why in next 10 years, India cannot be a preferred seat of arbitration. There is a lot to be done. The impression created is of 40, 50 years, which cannot be, erased in 10 years. But we have come a long way. And in the next 10 years, if everything goes right, and if the legislature and the judiciary follows the same trends and path and uses international practices, I don't see a problem. In 2030, we would be as successful as our neighboring jurisdictions such as Singapore and Hong Kong, etc. Lomesh, anything you would like to add to that?
Yeah, just a couple of points, Shashank. I agree with you completely, but there are a couple of things that we need to do better. One is improve our legislative ecospace. I think the drafting of legislations, we've come a long way from 2015. I mean, prior to that, we had a lot of backlog. 2015, we have carried a lot of those forward in the positive way. 2019, we have made amendments, and there are further amendments that are needed in the Arbitration Act. Hopefully, that should come through. And I do see a lot of confidence for even foreign investors to have the seat of arbitration in India. And I think that trend is also changing, though I must add a note of caution that it's not changed dramatically. A lot needs to be done.
That's right. Okay, moving on. There are a lot of questions of law students who want to know what they can do. I think we've covered them. So any of you who have missed it, please go back to our recording. The panelists have given a lot of suggestions on what steps can be taken by you and which organizations to go to for courses. There is a question by a non-lawyer who says that if kindly share your views and observations on appointment of arbitrators who have not attended law school but are experts in their own field. So, Ms. Nidumari, we know that there has been an 8th schedule that was going to be included in the Arbitration Act, but now has been omitted maybe for more amendments. It did speak about professionals with 10 years or more of experience in different non-law backgrounds as well, who can then become arbitrators. But what else would you want to say to this gentleman?
Yeah, that's right, Medha. I think that's an excellent question, and that is also the sort of the theme of what we spoke earlier. The fact that arbitrators need not be restricted only to just the lawyers who are practicing in the arbitration space. I think a lot of institutional arbitrations, what they are doing is they're empaneling a lot of experts. They do have a panel of experts depending on the area of practice that this particular person belongs to. They have those empaneled experts, and depending on the nature of dispute, they do reach out to them. So if the gentleman who's asked the question, he intends to take his career forward as an arbitrator, he would be advised to also sort of get himself empaneled in a lot of these arbitration institution centers. Because usually what happens is, if you're an expert, it's very rare that you will act as the sole arbitrator. It's not usually the case. We do find that typically with a 3-panel arbitrator. That's because there is usually somebody else, either an arbitration practitioner or a retired judge, who will bring with him or her the requisite experience of how to conduct the arbitration as well. So if he or she who asked the question wants to improve their skills insofar as how to conduct the arbitration, again, it goes back to all those courses which are available on how to draft an arbitral award, etc., where they can actually get those technical skills as well to feel a lot more comfortable in handling a sole arbitration as well.
All right. Thank you. And then there's another question, very interesting. How do law firms deal with conflicts if a law firm partner is being appointed as an arbitrator?
So it would be, again, it would be governed by Schedule 5 and Schedule 7, which has been adopted, from IBA guidelines on conflict of interest. So I think it is exactly the same way as you would do for a matter conflict check. The same things would happen if a law firm partner has been appointed as an arbitrator. In what capacity he has been appointed, whether in his individual capacity, what is his role with the partnership, etc., will be some of the factors. But otherwise, same eligibility criteria as per Schedule 5 and Schedule 7.
Yeah, I just have one point, Medha, on this, and I can share my own personal experience. I think I would have lost more than 6 to 10 mandates to act as an arbitrator because of conflict situation. And the problem is conflict, as per the schedule, is not just conflict insofar as my matter is concerned. It could be any other matter that the law firm handle. And if you have 50, 60 partners sitting across, then the chances of you getting conflicted out is very, very easy.
That's
so
right.
that really comes back to the point that a lot of foreign arbitration practitioners who were earlier with law firms who want to focus their practice maybe a lot more on arbitrations actually have quit law firms so that they do not get into these situations.
That's true. That's actually
Absolutely
true. There is a question on tribunal secretary opportunities. Please look into CIRB, website. There's a lot of information on that.
Even HKIAC has a course on tribunal secretaries, so one can do that.
Those will give you the information. Apart from counsel, I feel availability of material in the field of arbitration available for young lawyers should be more open and accessible. Almost everything important is being behind the paywalls, I believe. I think it's to do with confidentiality and perhaps lack of arbitration awards being there. If there's any thought from the panelists on this.
I was not able to follow it. It sounded very cryptic to me.
It did. And I can only
Lomesh has been able to decipher it.
Even I wasn't. Maybe it's.
Yeah, I wasn't able to.
That's the one.
I was waiting for Shashank to take the lead on this.
Okay, well, there was a question for Mr. Bhasin. He's not here, so we'll move on. How are arbitrators looking at online arbitration procedures?
There's plenty. We've discussed it. IF has come out with guidelines to conduct arbitration online. Many institutions have come out with their practice note on virtual hearings, even in domestic regimes. So there is plenty already there. If one wants to look out at what are the practices, what are the measures, and what are the precautions to be taken, and how especially recording of evidence, etc., how it is to be done on a virtual mode. There is now plenty in the public domain.
Right. Is it allowed neutral and lawyers can go for marketing? I don't know, and I think we can move on. How can students, again, there's a lot of question on how can students become arbitrators? Is LLM one of those ways? And I think Mr. Garg did mention LLM is certainly one way to achieve the skill set, but there are many other courses. Please go back to our recording and there'll be enough and more information on that. I think with that, we have finished all our questions and in time, just 4 minutes over the clock. Thank you so much.
Lovely.
Thank you so much for all
your
your valuable.
Thank you so much, Medha.
Thank you, Medha. Thank you for the excellent. Thank you, Shashank.
Thank you. Thank you, everyone, for what I feel was a most enlightening session. I think speaking from personal experience, the landscape is surely still less than ideal for young practitioners and for women nowadays. But I think if there is a time for us to make our mark, I think this is the time. I would like to invite everyone also to join us for the 3 other sessions we have today. At 12 noon, 3 p.m., as well as 6 p.m. Indian Standard Time. We do look forward to having everyone with us again. And thank you again to a very distinguished panel and for all the insights that you have shared with us over the course of the past hour. Thank you, Medha, for really going through all the Q&A questions. We really appreciate everyone spending time with us today. Thank you, everyone, again.